Hello, I'm Geneva, founder and attorney at Promise Law. I want to talk with you today about planning for unmarried couples. Now I know this doesn't surprise you, but sometimes not everybody decides to get married, right? There can be a whole host of reasons for it. But the reality is, many couples live long, happy, healthy lives together and enjoy each other very much, even without the formality of marriage. What they don't know sometimes is when health fails or circumstances change, why it is vitally important that they have planning in place. So I'm going to cover just a few of the ways that unmarried couples are impacted. First of all, let's talk about lifetime decision making. We all operate from the position of we'll be alive and well and able to make our own decisions, which is all well and good until we can't. Now, what happens if you can't make medical decisions for yourself anymore? Will your longtime sweetheart be able to do so? Your life's companion? The answer to that question is likely no. In the absence of proper estate planning documents, the rules that govern medical decisions say it doesn't matter how long you've been with someone. It doesn't matter that they are your life's partner. The person who can make the decisions, the adult children, maybe your parent, an adult sibling. Now these might be fine decision makers, but maybe they're not who you want to make the decisions. After all, you've dedicated your life to this other person. But that's the default rule without any planning. Another way that unmarried couples find themselves in a jam during their lifetime has to do with managing assets. If they have some agreement or arrangement about I own the house and you pay for this, I pay for that, again, it's not an issue until one of them can't make decisions for themselves anymore. It could be an accident, it could be an illness, it could be that they've just lived a very long life and are starting to decline mentally, and they just can't make decisions anymore. Again, an estate plan is critical to making sure you put your partner in place to make those decisions. Without proper documentation, the alternative is petitioning the court to name a guardian and conservator. Now, the person petitioning can ask to be appointed, but the court isn't required to do so. In fact, the court standard is just to appoint a suitable person, and the person who's suitable might not be the partner. And you really want to leave that to chance. Another place where unmarried couples run into troubles is at the death of the partner. I know that it might be the case that if you've been together lots of years, you think, well, certainly everything's going to go to this other person. And sometimes that's a mistake of law, misunderstanding the rules. There's no common law marriage in Virginia. So unless you're really married, those assets are not going to go to your partner who you've long considered to be the equivalent of a spouse to you. The first person who would receive those are any children that you might have. Again, parents if they're living, adult siblings, well, any sibling, or if a sibling's died, their children. So the truth is you actually have an estate plan right now, and it's the state's rules if you haven't put one in place. If you've dedicated your life to another person and just haven't gotten to the formality of marriage and don't intend to, then your next step should be to call Promise Law. We've helped lots of families, even unconventional ones, organize their affairs to make sure they take care of those people, organizations, and everyone who matters most. Remember, life happens. Plan on it. Start your plan today.